Thank you, Mr. Hibner, and thank you, Mr. Scales and Mr. Dean, for agreeing to present your oral argument today by live streaming video conference. And we are live streaming to fulfill our obligation to have open courts so that the public may view and observe what our court is doing. And we will conduct the hearing today in the same fashion as if you and we were in the courtroom and you were presenting arguments there. Each of you have 15 minutes, and the appellant, Mr. Dean, has chosen to reserve 5 minutes of his 15 for rebuttal. Thus, the clock will be set at 10. I do ask the attorneys, if it's not your time to speak, if you would mute your microphone, and of course, when it is time, unmute it. If there is nothing else, Mr. Hibner, would you call the case?
Noah L., a minor child, versus Sumner County Board of Education.
All right, thank you. And Mr. Dean, you have the floor.
Please, the court. I want to start out by talking about really the facts of the case and what I believe that the court largely ignored and didn't cite that I think is critical to this case and the facts of it. I'll be candid with the court. When I first took this case, my clients came to me and I wasn't all that excited about it in terms of the liability case. But then when I took the depositions of the custodial staff and learned just what they really knew about the propensity of these chairs and how much that they fell off and the risk that they presented, I thought that the case was much stronger than I initially ever thought it would be. But those are the facts which I think the court really ignored, didn't cite them at all. But looking at those facts, and all of us, when I took this case, and I'm sure when you guys think, we all think back to school when we were in school. And hopefully none of y'all are old enough when y'all were in school, maybe like my dad. I remember they had the old desk with the seat was in front of the desk in front connected to it. Hopefully none of you.
That is exactly what I had.
You're of my dad's generation. We didn't have that. We had these very similar melamine chairs, metal construction with this hard, heavy, almost like a clay type substance. And that's the same thing that this is. And when I took this case, I thought back, well, I remember being in school. I remember my science teacher that at the end of class in now it's 5th, 6th grade, she made us put those chairs up on top of the desk. And I remember them banging down and falling down. In fact, I remember one day, I think she got mad and might have sort of knocked one of them down. But in any event, the hard part about this case is isolating out our own preconceived notions about our lives and us being in school and looking at this really from, is this a safe circumstances? What did they know what was going on? But the facts that I think are crucial, which were ignored completely by the court, weren't cited in his opinion, is the custodial staff. And they make clear, and it's clear in the record, they knew that these things had a propensity to fall. And in looking at, well, how easily are they dislodged? You know, are they, nobody has presented any expert or anybody that says they should be stacked upside down on top of the tables. She says, the custodial lady says they're meant to be stacked on one another. But nobody has any literature data, and I've looked all over the place, of the appropriateness of sticking a chair upside down a table. But my analogy to this is if we were there at y'all's at the Court of Appeals and we stuck the chairs upside down on counsel's table, and every time somebody came in, at some point, somebody'd probably knock one of them loose and it'd fall down. And it's just probably what happened. When we took the custodian's depositions, they acknowledge this happens. It happens on occasion. It's inevitable. It's going to happen again.
Let me ask you this, Mr. Dean. Are you pursuing this as a premises liability case or a general negligence case?
Well, I think it could fit into both contexts.
Well, why don't you tell me which one you think it fits into? Because the court resolved it as a premises liability case. Is that right?
That's correct.
And you are not saying that the court erred in treating it as a premises liability case. I understand you're saying that the court made the wrong judgment. Okay. but you're not saying that the court erred in treating it as a premises liability case, are you?
Well, I think
At least I didn't see that in your brief.
I don't think they erred. I think you could analyze this case under general negligence principles as well as what the courts have set forth on premises liability. It sort of fits both.
Okay. All right. So I'll just, okay. All right.
But I think if looking at it at its core, going back to your traditional slip and fall, is this, I've had cases you'd think that is this an unsafe, dangerous condition? And their argument is, and the court found, well, this isn't foreseeable. It never hurt anybody before. And that's, I want to get at it. If this was a chair sitting up 3 or 4 feet higher and it was stuck on top of a book, let's say we were in a library and they put it on top of a bookcase 4 feet high, the undisputed facts are it just takes the bump of an elbow to knock one of these loose. The undisputed facts are the custodians say this happens, it happens, and they use Webster's dictionary. It happens occasionally. It's happened. It's going to happen if they keep doing this. But if we stuck up a seat 4 more feet higher in the air, would anybody say, well, that thing could fall and hurt somebody? I think we'd all say, well, yeah, golly, that could fall and hurt somebody. But we put it down on the desk level and we start analyzing this. And where I think one point that the court was wrong, the court basically said I had to get an expert for this. And I'll tell y'all, I've looked around. I don't know how an expert could help us any more than we have the custodian saying, we know this is happening. I even had one custodian says, her testimony agrees, this is unsafe.
Mr. Dean, is there any evidence of how heavy each chair is and how sharp or blunt the edges of the chairs are?
Well, I mean, in terms of, we know that it severed off the young man's hand, but is there any expert who can analyze, what's the nature of the blunt force trauma, which could result from the dropping of one of these chairs? Obviously it could cause an injury. It severed a finger.
All right. In the premises liability elements, one of them is the likely seriousness of the foreseeability of a serious injury. How foreseeable was it that a serious injury would occur as opposed to somebody bumping a chair and it falls and it bruises somebody's ankle or shin?
Well, I mean, if we look at, they claim that this has never happened before, and I can't refute that, that nobody's ever been hurt before by this. So to the extent, have we gotten into what could happen that almost gets into, you're looking at the type of injury versus that we have an accident, and these are an accident which is foreseeable to occur, that it will fall, not that the accident will result in someone being injured. But that's getting more at looking at the specific nature of the injury which is caused. And the nature of the injury doesn't have to be foreseeable, just that an injury would be foreseeable. And I think you're
not saying that these chairs fall on their own wouldn't be on their own, but by just the force of gravity alone, are you?
I'll read you what Miss McDaniel stated. This is Miss McCampbell. There's 2 janitors. Stated Miss McCampbell acknowledged and agreed any manner of contact with the chair could cause them to.
Some outside actor has to act to cause these chairs to fall.
Correct.
These tables aren't cantilevered or slanted so the chairs slide off. If they're put on the table at rest, they remain under Newton's, first or second law, they remain at rest, correct? I guess Newton's first law.
Correct. They're not falling by themselves. I think that's they talk about the orientation of the chairs. I call it the precarious position of the chairs and the nature of just how little force it takes to remove them off, how to move them. And the custodian said, it doesn't take much force to knock one loose. Just an elbow would knock one over, and that the kids frequently knock them off with their backpacks. They're not paying it, and they know kids don't pay attention to what they're doing. And in this case, this is an 11-year-old child. It's not in the record. He's disabled. It doesn't make any difference. This is a disabled kid. They owe this duty to every child in this school if they know something's an unsafe condition. But looking at that this is a lie, and they're still doing this. They're not. The Circuit Court of Sumner County has condoned if the next kid that this falls on and hurts. And that's one of my points. They say, well, this has never happened before. Well, if it happens again, does that change the analysis in this case in some way? In terms of looking at the other elements of, is it a dangerous condition? And God forbid the next kid who has this happen, or what if this would have been a 5-year-old or 6-year-old? But
pardon me, Mr. Dean, we got to deal with the summary judgment here. Other than the testimony of the janitors, what other evidence of any of the elements of a premises liability case are there?
I think the janitorial staff established actual notice of the risk of
Actual notice of what?
That this
of the risk?
That this could easily fall and become dislodged by inadvertent contact. They were on they're on notice, and they didn't dispute this is happening.
Okay, I understand that. Okay.
So that's
got our notice. Is that the evidence? Is that all the evidence?
Well, no. Well, I want to get into the foreseeability issue of it.
What evidence is there of foreseeability?
That these chairs, in fact, have fallen many times before, and it is a regular occurrence that they're dislodged and fall to the ground.
Okay. All right. Okay.
All right. Thank you, Mr. Dean. Your first 10 minutes are up. Mr. Scales, it's your floor to argue.
Thank you, Your Honor. May it please the court. My name is William Scales, and I represent the defendant / appellee in this case, Sumner County Board of Education. As Mr. Dean's indicated, this is a personal injury case in which there are two claims, one for premises liability and one for general negligence. And the trial court dismissed both of those claims, at least based on my reading, for lack of proof. And this court should affirm that ruling for 3 reasons. The first, we submit that the plaintiffs have waived their appellate issues because their statement of issues does not comply with Tennessee Rule of Appellate Procedure 27A4. The second reason is the court should affirm the premises liability grant of summary judgment because there is no proof in this record that the chairs or their placement on these tables constitutes a dangerous or defective condition. And then the third reason is with respect to the general negligence claim that Noah's injury was not foreseeable. Now, we begin with the waiver of appellate issues. The statement of issues here is very general. It doesn't specifically identify any error or fault on the part of the trial court. It doesn't say that there were disputes of fact. It doesn't say that there were misapplications of law, and it does not indicate which claim or either claim is the subject of this appeal. The first time we learn anything about this in the statement of the case, which seems to limit this case, assuming there was no waiver, seems to limit the case to just a premises liability case. And so either all claims are waived, or if the court finds that their general statement of the issues is accurate, this case is limited to the premises liability claim, and they've waived the general negligence claim. With respect to premises liabilities, the court is aware there are 4 elements, but we're going to focus on 2 of those elements. We're going to focus on the dangerous and defective condition that caused an injury element and the actual or constructive notice element. Now, with respect to dangerous or defective condition, as the plaintiff, they have the burden of proof. They have to prove that something was defective. And expert proof is required here to help us understand why a chair that rests on a table and doesn't move without outside intervention is somehow defective. As I've noted, they've not designated an expert. There's no expert report. And there's no state or local policy that says this practice is forbidden. As the court has noted, the only testimony here, the only proof is the custodial staff's proof. That's Ms. McDaniels. And she did testify that she believes these chairs are unsafe. She did testify that children bump into these chairs and that they may have fallen. And the plaintiff even testifies that these people bump in these chairs and they may have fallen. but no one has testified that there's been an injury.
So pardon me, Mr. Scales,
Yes.
under summary judgment jurisprudence, are you taking the negating an essential element approach, or demonstrating that the evidence is not sufficient to establish the claim approach?
I think you could do it both ways, Your Honor. I mean, certainly it's a failure to have the proof to establish, but you can also show they can't establish by showing they have no proof to do it. And in order to survive summary judgment, you have to show there's a genuine dispute of material fact. And if you have no proof, you can't establish facts, and there can be no dispute. And here, there is just absolutely no proof to support that there's a dangerous or defective condition, at least with respect to this issue. And we'll see as the argument continues, there's no proof to support the actual knowledge or the foreseeability. Does that answer your question, Your Honor?
Yeah, I had asked Mr. Dean about that, and he talked about the testimony of the custodians, and so I asked, creating an issue of fact in that regard.
Yeah. We don't believe that there's any issue of fact regarding Miss McDaniel's testimony. But the thing is that her testimony is lay testimony. It's not expert testimony. It's her opinion based on her observations. And her belief that these chairs are unsafe does not make them scientifically unsafe, does not make them unsafe for purposes of this litigation. If I could, I'd like to direct the court's attention to the Goomis versus Mays case. And in that case, the court says that negligence is not to be presumed by the mere happening of an injury. So the mere fact that these chairs fell and injured Noah is not proof of negligence. In that case, it was a case in which the plaintiff was moving brush in a yard, and the plaintiff slipped on a rock and broke 2 bones in their right arm. And the court said in that case that the rock was not dangerous defective. It would just happen to be that this person slipped and fell on this rock. The rock was open and obvious. There was no rain that day. The weather was clear. Analogizing it to this case, when this injury happened, it wasn't as though the chair spontaneously leapt from the table. Noah, and just to kind of talk about how this happened from a factual perspective, Noah was sitting at a table. The table behind him had chairs still stacked on them with the butt of the chair face down and the legs up. So it's flat on the surface. As he stands up, he trips over his own book bag. As he's falling to the ground, he pushes the chair he's in out of the way to make sure he doesn't fall on that chair. He inadvertently pushes that chair into one of these resting chairs, and one of those resting chairs falls on his hand. So this is not a situation where the chair just falls down. There was significant force where he pushed the chair into the other that caused it to come down. And so, again, Ms. McDaniel's testimony does not make these chairs inherently dangerous. This is no different than if we were in a library and he were to trip over his book bag in a library and bump into a bookcase and a book falls down. That book on that bookcase is not necessarily defective because it fell down. There was some outside intervention that caused that. And I believe that Goomis case indicates that. With regard to actual or constructive notice, as the court's aware, actual notice is, this has happened before. And as Mr. Dean concedes, this is like, there's never been a reported injury related to the placement of these chairs or these chairs in this school system, or in the White House Middle School. Constructive notice. That is kind of the circumstances charge the Sumner County Board of Education with knowledge. Here, I believe the plaintiff's testimony, his mother's testimony, make clear there could not be constructive notice. Noah, when he talks to his friends about this accident, this injury, calls it a freak accident. Noah's mother refers to it as an absolute accident as an unfortunate accident. Now, for the first time on appeal, during this appeal process, the plaintiffs introduced this method of operation theory, which is now referred to as the common occurrence theory. And in order to, first, assuming they haven't waived it by just offering for the first time on appeal, the way that a plaintiff can avail themselves of that theory is by showing that the dangerous condition occurred in the same approximate location or in such a frequent manner that the happening of the condition was foreseeable. And I want to focus on that frequent manner language. There is no evidence in this record of how frequently these chairs fell. We don't know if it was once a week, twice a week, once a day, once a month. We just don't know. All we know is that they were bumped at times. The bumping sometimes led to them falling, and people heard of them falling. That's all we know. And that is insufficient to establish a frequent pattern. So to the extent that this common occurrence theory is available to the plaintiffs, again, they don't have the proof to avail themselves of it. Finally, with regard to the general negligence claim, in Tennessee, there's a specific standard that's applied to schools and teachers. And the KGR versus Union City School District case, which is cited in our papers, sets forth kind of that standard. And I'll read it here. It's that teachers and local school districts do not have a duty to anticipate or foresee the hundreds of unexpected student acts that occur daily in public schools. But teachers and local school districts do have a duty to safeguard students at school from reasonably foreseeable dangerous conditions. And there are 4 facts here that demonstrate this was not a reasonably foreseeable accident, all undisputed. There were no prior reported injuries. Noah himself testified that prior to the incident, he had no concern about these chairs falling or injuring anyone. Noah's father testified that he had no concern about these chairs falling or injuring anyone. And again, I'll repeat, there is no state or local policy that forbids displacement. Now, there are 2 cases that we've cited in our briefing that we think reinforce our position that this accident was not foreseeable from a general negligence perspective. And those cases are the McCann case and the Nicholson case. Those are both school cases where students were injured pretty severely at school. The McCann case was a student who was at PE. It was a relay event. There are 4 lanes. He was one of the middle 2 lanes, and the middle 2 lanes were on concrete. And the task was to run 40 yards forwards and then run 40 yards backwards. Well, as this student was running 40 yards backwards, he lost his balance, he fell, and he fractured his skull, causing permanent injury. Well, in that case, this court affirmed summary judgment, noting that the student was injured engaging in activity he'd done previously. And the court also noted that the child had no disability that made this activity inappropriate. Analogizing that case here, Noah had been in that lunchroom on innumerable occasions. He'd seen these lunch tables on innumerable occasions. He wasn't concerned about his safety in this lunchroom. It was only his misstep that caused this injury. The second case, that Nicholson case, young girls are in a classroom. They're playing tug of war with a ruler. And one of the girls managed to hit another girl in the eye with the ruler, causing permanent injury. And in that case, this court affirmed summary judgment, noting that an object that's capable of inflicting injury does not make it per se dangerous. So here, there's no question that this chair injured Noah, no question. But that does not make this chair in and of itself defective. There needs to be expert proof that says, because this chair is on this table in this manner, it's unsafe. Subject to your question, Your Honor, those are our arguments.
All right, hearing no questions. Thank you, Mr. Scales. Mr. Dean, your rebuttal. Be sure to unmute.
I've got it back on. let me just respond. In terms of the waiver of the appellate issues, this is a really simple issue, and I know it's a really, so did the court get summary judgment right? So hopefully I succinctly stated the issue which is before the court is, was summary judgment appropriate? So I don't think I've waived the issue on the appeal of whether summary judgment was appropriate. This is a de novo review, is the standard with which the court reviews this. Excuse me. I want to really hit on the expert proof issue, because to suggest that in a case as simple as this, that my client has a burden to get an expert, that I've got to go find somebody, and maybe Mr. Scales can tell us what type of expert we could get that could tell us anything that could assist us in knowing any more about a chair falling from a table. A chair that,
well, maybe an expert could tell you how much force was required to remove these particular chairs from a table. I mean, it sounds like from the description of the accident here is that the chair that the child was sitting on was pushed into another chair with some force. I mean, wouldn't it be helpful to know how much force is required for one of these chairs to fall?
Well, I think that the evidence of the custodians is that it takes very, very little force.
Like, well, how much of that is in foot-pounds? I mean, what does that equal?
Well,
very little force, is that, I mean, what is that?
Does the trier of fact in every negligence case have to know these technical things to make a determination about whether an issue is unsafe? I don't think so. In terms of how many foot-pounds per square inch it takes, the woman said it took as little as bumping an elbow, a backpack hitting against it. I will state with regard to the facts, there's nothing in the record about really the extent to which the force that the chair hit it, whether it hit it hard or whether it hit it light. We just know that it dislodged it, and we could expect him to be dislodged.
Well, whose burden is that then? Isn't that part of your case?
Yes,
isn't that part of your case of proving liability? And that's what I asked you before. The only evidence that you have put out there is the testimony of the custodial staff, right?
That's correct, because other than the children who interact with these are the people on the ground at the school. They're the ones who decide to do this the way that they do it. They're the ones that deal with them. And so who else, in this world realm of who at the school would know anything about how easily these things fall off other than kids and what we could all observe as lay people with a chair sitting upstairs.
Well, it's not only that they fall off, but the circumstances under which they fall off. Like someone said, the wind just doesn't blow them off.
Correct.
Or something like that. And this is one where the proof is that Noah's backpack got caught and he tripped over that and bumped into the is that the proof?
Yeah, correct. We had inadvertent contact with these chairs, which is why they fall down and why they fall down every time that they fall down. But this would not occur, and he would not have been injured in this manner had they not had those chairs sitting upside down waiting to fall. But in terms of my burden, have I shifted the burden? And in a light most favorable to me, I've got a janitor saying this is unsafe. I've got a janitor saying these things fall. They've fallen in the past. They're going to keep falling. Then they're not changing the way they're doing business. This court, the circuit court, has basically said this is okay, and so they're going to keep falling, and so it's inevitable that they're going to fall if they're continued to be done in this manner. And that's why I think it's important for us to step outside of this, looking at this as a cafeteria room table, and look at the rest of our daily lives interactions. And if we stuck a table on top of a chair, and you got to look at this in the context of children, but let's say this was a nursing home, assisted living facility, and they were sticking all the chairs upside down, and residents were coming in and they were knocking them off, and no residents got hurt until finally one of them fell on somebody such a manner that it hurt them. Would that facility, who knew that that knew that it had a propensity to fall off and easily fall off, would they be liable for that? And I think without question they would.
All right. Thank you, Mr. Dean. Your time is up, and thanks to you and Mr. Scales for your arguments today and participating with us by video conference for our live streaming hearing of your oral arguments. That concludes the case, Mr. Hibner.
This court is now in recess.
Thank you.
Gentlemen, you can leave the meeting now.